Hello, I know you guys miss me, and I'm back. This We the People News, okay? Educational purposes only. Y'all, I'm not going to repeat this again, just so you guys have notice, okay? I'm not the brightest tree on a summer day, okay? Matter of fact, if you drive down the road and you see a dead tree, that's me. Always do your own research, okay? I'm hearsay. My research is my research. Your research is your research. But the one thing I want to keep out pointing out to you when you do your research, never look straight forward. Always look around you, be able to protect yourself by any means necessary. Now, my opinion only, since I cannot give legal advice, and this is educational only, um, there's been a lot of Supreme Court cases on the Second Amendment. Now, this is going to be my take. And all these attorneys and people fighting all this things and going through all these court cases over and over and over. If we actually have one good attorney and ask one or two couple of simple questions, and it's this: if our founding fathers had machine guns, would they use it when they're fighting uh, against the redcoats? Well, if you think it's yes, as I do, all right, there's original intent. All right. Number two, and when they won against the redcoats and we became our own separate nation, would the Second Amendment still say what it would say today? Would the Second Amendment actually be the exact same? If you vote yes, as I do, well, problem is solved. Now we go back in, and when they created the thing of machine guns and all that kind of stuff, well, now that's unconstitutional, and everything after that is null and void. Okay? Now, I understand there's arguments out there on both sides of nuclear bombs and this, that, here, and there. And I have to say, that's a tricky one because I don't like the government having that much power over the people. But the issue is, just as I don't really so much trust government, I don't really trust extremely rich people. They're self-interest, right? And they'd be the only ones that have the money to actually be able to take care of the nuclear arms. So due to that reason itself, I think that would be a limitation against the people to actually own such deal, and that would be the only reason, because you're gonna have the two evils instead of one evil. Right? We cannot have two evils above us. They're already bothering us enough as it is. They're paying off Congress and all that to violate our rights every day under the Administrative Act of 1947. So there is my answer. However, anything below that, tanks and this, that, here, and there, um, it's left to the state militia. We, the people, as long as we can have access, just in case of time and need, that we would be able to have access to the tanks and all that kind of stuff. But I don't think we should just own tanks and be able to drive it out on the road. But that being said, I think we should be able to own tanks if you have 34 acres out there and be able to play around. All right. So there is my answer in that case. If the founding fathers used these things, would the Second Amendment still be the same? And I vote yes on both. So therefore, the machine guns is unconstitutional, and the judges had to look at allegedly, if you have good judges, which have been ruling pretty good, okay? But attorneys are not bringing up the right standing, people. Everything is about standing, okay? Let's go on about the 10th Amendment. Whoop. All right. Let's see here. Sorry, I told you guys I actually went through it a little bit and I thought it was pretty good. Okay, so here we go.
74 pamphlet, A Summary View of the Rights of British America, where he not only took the position that Parliament held list of grievances with the British 2 years before the
Wow.
These acts are a nullity, and we declare them void. That's
John, Miss
These acts are a nullity, and we declare them void. That's how Thomas Jefferson described a long and detailed list of grievances with the British 2 years before the Declaration of Independence. On this episode, I'm going to go through the highlights of Thomas Jefferson's almost totally forgotten and ignored 1774 pamphlet, A Summary View of the Rights of British America, where he not only took the position that Parliament had no right whatsoever to exercise any authority over us, but he also included a laundry list going back more than a century of British laws, both internal and external, that he saw as unconstitutional and void. But first of all, before getting to that, welcome and thank you for joining me here on the path to liberty. My name is Michael Bolden with the 10th Amendment Center, and this is the show for Friday, September 6th, 2024. But of course, we are going back in history all the way to September 5th, 1774, when delegates from 12 of the 13 colonies met at a place called Carpenter's Hall in Philadelphia for the start of what we call today the First Continental Congress. But even before that, back in July of 74, Jefferson started writing this pamphlet with a goal of persuading the Virginia delegation to take a really strong stand, a strong posture towards Great Britain, and that is now called A Summary View of the Rights of British America. We don't know if he gave it that title or someone else, from my understanding. Now, here from the Virginia Museum of History and Culture, they point out that he pretty much got the job writing the Declaration because he essentially had already written the Declaration in his 1774 Summary View, a landmark in Virginia history. It really is a landmark in American history, in my view. He included in it a strong attack on the king, a rejection of Parliament having any authority over the colonies at all. A lot of people, of course, at the time thought the British could have power over external trade, and Jefferson said, nothing, you have no authority at all. He had a condemnation of slavery and the international slave trade, and included a power of the people of the colonies to declare British acts both a nullity and void. Mike Maharrey points out that in many ways, A Summary View was a precursor to the Declaration of Independence. Many of what Jefferson called unwarrantable encroachments and usurpations, you'll see very similar language like this in the Declaration, Jefferson outlined there reappear in the Declaration. But let's get right to this. Here's the first sentence. It was a quote from one of Jefferson's favorite Roman writers, Cicero, and it was aimed...
Okay, so again, I'm going to give a little bit of notice right here, right? This right here was really kind of the petition of our First Amendment of the grievance, right? And this was really the original intent of the Constitution. So when we talk about original intent, even when the Supreme Court talked about the Second Amendment original intent, the original intent is right here, okay? And the true original intent is to really look at the history of the first king of what we call today England.
You can tell directly at the king rather than Parliament, but there's plenty for Parliament too. And he wrote, "It is the indispensable duty of the supreme magistrate to consider himself as acting for the whole community, and obliged to support its dignity, and assign to the people with justice their various rights, as he would be faithful to the great trust reposed in him." And he continued.
So think about that. Our magistrate was supposed to do a kind of equal justice. But we are finding out that we actually have to fight all these things up to into the federal courts when all the other lower courts know that we shouldn't have to. It's because the lower courts are disgusting. There's no reason why at all we should enter the federal courts for any particular lawsuits at all, people. If we had a just judicial branch in due course and good standing in good faith today.
With this, and this is, well, he is no more than the chief officer of the people. He's taking the position that government at any level, even a king, is merely an agent of the people. He is no more than...
What? What? Agent for the people? Huh. Wait a minute. That's a far cry from what we have today, people.
A chief officer of the people, appointed by the laws, and circumscribed with definite powers. Even the king, according to Jefferson, would have limits on his power. And it was there to assist in working the great machine of government, erected for the use of the people, for their use, and consequently subject to their superintendence. Now, if you think about it, Jefferson here is really describing what would eventually become the model for the president, for the executive branch, and the entire system under the Constitution for the United States some years later. That is, the people are sovereign. They hold final authority. All power flows from the people of the several states, and government at every level, no matter what their title may be, they're merely the agents of the people. Now, of course, the British wouldn't agree with that. They probably thought it was ludicrous to even suggest such a thing. But Jefferson pushed on anyways, and he based much of his position, his philosophical take, on natural rights, natural law, including a right to local self-government.
And don't you hear that in the Constitution? And I'm going to take it a step further, and I said this a few times over. The law of nation, right, separates everything as well, right? Men and women have natural rights. The people have political power, which can be called citizens, but it would be with a capital C, okay? And it would be under the inhabitants. Now, citizens itself would be the government employees, okay? So think about this. So, the president's a citizen, Congress is citizen, all the government bodies that work for them is citizens. But it's not the people. They are not the people. They are citizens. In fact, if you really want to sit and think about it, they are the 14th Amendment citizen. But in the law of nation, they're not so much as subjects, but as servants. Okay? But they're the lowercase c. They're not the capital C citizen. They're the lowercase c. That's the reason why in the 14th Amendment, I'm led to believe and do believe, that's the lower c and calling us citizens because they are treating us as one of the government employees and not the leader as we are described as for the people. Okay? So I'm just saying, do your own research.
And he said, our ancestors, before their emigration to America, were the free inhabitants of the British dominions in Europe, and possessed a right which nature has given to all men, departing from the country in which chance, not choice, had placed them, of going in quest of new habitations, and of there establishing new societies, under such laws and regulations as to them shall seem most likely to promote public happiness. Very similar precursor to the Declaration there as well. He continued with this, that settlements having been thus effected in the wilds of America, the emigrants thought proper to adopt the system of laws under which they had hitherto lived in the mother country. and to continue their union with her by submitting themselves to the same common sovereign, who is thereby made the central link connecting the several parts of the empire, thus newly multiplied. That's Jeffersonian flair to basically say none of this was by right of the British government, Parliament, or the king. The people had a natural right to leave where they happened to be born and to find a new place to live. John Locke, of course, talked about people were free to leave whatever society they were born in and go to a state of nature, for example. And certainly that's what the people did when they went to America. And then they have a free choice to decide what kind of laws they're going to set up in that area. Now, the people happen to, as Jefferson pointed out, voluntarily chose to go along with much of the system of the British. Not exactly the same, but they chose many of the same laws. And then they also made the free choice to stay in union. They chose in union to submit themselves to this common sovereign. So this was all of free will. Meharry points out that he went on to insist that the colonies were erected into distinct and independent governments. As such, Mike writes, they retained most powers, while the mother country was limited to exercising only a few specific functions. This idea was, again, carried over to the U.S. constitutional system, with the states, the people of the states, maintaining sovereignty with a general government delegated only a few specific powers. So Jefferson, really a precursor to the Constitution as well. Now, having established this foundational principle, these base principles based on natural rights and on choice to be separate, but still connected in a union, the colonies were essentially, in his view, sovereign states. They were attached to the British Empire only through the crown, and it was very limited. So then Jefferson started to outline some of the most prominent encroachments and usurpations that both the Parliament and the crown had committed, and they went back, way back. We're not talking just the Stamp Act, but a century before that as well. And Mike...
All right, we're going to pause there because we're at 17 minutes because I yappity yap yap yap. Again, without my interruption, 10th Amendment. Okay? There's my little thing for today on part 2. Like I said, this is going to probably be a couple of them because of my yappity yap yap. These are We the People News. Bye, y'all.